Some important concepts under legal ethics. Notary public, it is one appointed by the court whose duty is to attest to the genuineness of any deed or writing in order to render them available as evidence of facts stated therein, and who is authorized by the statute to administer various oaths. Quantum meruit means, as much as he deserved. It is used as a basis for determining the lawyer's professional fees in the absence of a contract. In determining attorney's fees, it means that the attorney will be paid for his services as much as he should deserve, when the services are prematurely terminated by the act of either of the parties, or by reason of death, disability or operation of law. Considering the importance of the subject matter of the controversy, the extent of the services rendered and the professional standing of the lawyer. Practice of law means any activity, in or out of court, which requires the application of law, legal procedure, knowledge, training, and experience. To engage in the practice of law is to perform those acts which are characteristics of the profession. Generally, to practice law is to give notice or render any kind of service, which device or service required the use in any degree of legal knowledge or skill. Lawyers, when they teach law, are considered engaged in the practice of law. Lawyers may be disciplined for misconduct even if committed in their private capacity, as long as their acts reflect want of probity, good demeanor, or good character. Rules on sharing of legal fees for legal services with non-lawyers. General rule: a lawyer shall not divide or stipulate to divide a fee for legal services with persons not licensed to practice law. Exception: where there is a pre-existing agreement with a partner or associate that upon the latter's death, money shall be paid over a reasonable period of time to his estate or to persons specified in the agreement. Where a lawyer undertakes to complete unfinished legal business of a deceased lawyer, or where a lawyer or law firm includes non-lawyer employees in a retirement plan, even if the plan is based in whole or in part on a profit-sharing agreement. IBP dues, being mandatory, do not exempt lawyers who are on inactive status. Payment thereof is a necessary consequence of membership in the IBP, the non-payment of which being a ground for disciplinary action. Requisites for the rule on privileged communication between an attorney and his client to apply. The legal advice must be sought from the attorney in his professional capacity. There exists an attorney-client relationship, or a prospective attorney-client relationship, and it is by reason of this relationship that the client made the communication, and the client made the communication in confidence. When rule on privileged communication not applicable. When there is consent or waiver of client. When the law requires disclosure. When disclosure is made to protect the lawyer's rights, i.e. to collect his fees or defend himself, his employees or associates, or by judicial action, and when such communications are made in contemplation of a crime or the perpetuation of a fraud. Money entrusted to a lawyer should be immediately returned to the client, if the same was not used for its intended purpose. Money entrusted to a lawyer for a specific purpose, such as for the processing of transfer of land title, but not used for the purpose, should be immediately returned. A lawyer's failure to return upon demand the fund held by him on behalf of his client gives rise to the presumption that he has appropriated the same for his own use in violation of the trust reposed to him by his client. Exceptions to the rule that the negligence of the counsel binds his client. Where reckless or gross negligence of counsel deprives the client of due process of law. When its application will result in outright deprivation of the client's liberty or property, or where the interests of justice so require. Attorney's fees. Factors in determining the amount of fees paid to a lawyer. Contingency and certainty of compensation. Character of the employment, whether occasional and established. Customary charges for similar services and the schedule of fees of the IBP chapter to which he belongs. Amount involved in the controversy and the benefits resulting to the client from the service. Probability of losing other employment as a result of acceptance of the proffered case. Professional standing of the lawyer. Time spent and extent of the services rendered or required. Importance of subject matter. Novelty and difficulty of questions involved, and skill demanded of a lawyer. The totality of the lawyer's experience provides him the skill and competence admired in lawyers. When quantum meruit applies. There is no express contract for payment of attorney's fees agreed upon between the lawyer and the client. When, although there is a formal contract for attorney's fees, the fees stipulated are found unconscionable. When the contract for attorney's fees is void due to purely formal defects of execution. When for justifiable cause, the lawyer was not able to finish the case. When the lawyer and the client disregard the contract for fees. Grounds for disbarment or suspension of lawyer. Deceit, malpractice or other gross misconduct in such office. Grossly immoral conduct. Conviction of a crime involving moral turpitude. Violation of oath of office. Willful disobedience of a lawful order of a superior court. Corruptly or willfully appearing as an attorney for a party to a case without authority so to do, and disbarment in foreign jurisdiction. Note, the grounds for disbarment are not exclusive. Purpose of MCLE. Keep abreast with law and jurisprudence. Enhance the standards of the practice of law, and maintain the ethics of the profession. When may clerk of courts of regional trial courts notarize. The notarial fees received in connection thereto shall be for the account of the judiciary, and they certify in said documents that there are no available notaries public within the territorial jurisdiction of the RTC where they are stationed. The jurisdiction of a notary public is limited to the territorial jurisdiction of his commissioning court. A person commissioned as a notary public may perform notarial acts in any place within the territorial jurisdiction of the commission court. Outline of the new Code of Judicial Conduct for the Philippine Judiciary, Bangalore Draft. Canon 1, Independence. Canon 2, Integrity. Canon 3, Impartiality. Canon 4, Propriety. Canon 5, Equality. Canon 6, Competence and Diligence. Bias and partiality of the judge must be proved by clear and convincing evidence. Bare allegations of bias and partiality are not enough in the absence of clear and convincing evidence to overcome the presumption that the judge will undertake his noble role to dispense justice according to law and evidence and without fear or favor. There should be clear and convincing evidence to prove the charge of bias and partiality. Extrinsic evidence is required to establish bias, bad faith, malice or corrupt purpose, in addition to the palpable error that may be inferred from the decision or order itself. Administrative jurisdiction of the SC over judges and justice, all levels. The SC exercises its administrative supervision over all courts and personnel through the Office of the Court Administrator. Judges should treat directives from the OCA as if issued directly by the court and comply promptly and conscientiously with them, since it is through the OCA that the court exercises its constitutionally mandated administrative supervision over all courts and the personnel thereof. Unjustified failure to comply with such directives constitutes misconduct and exacerbates administrative liability. This will be the last episode for my some important concepts under the 8 bar subjects. If you haven't watched the other episodes, you can check them in my Study With Me playlist. I will leave the link in the description.